This episode of the Not Too Stuffy Law Show is brought to you by the following sponsor.
Hello, I'm attorney Sharon Sockamup. If you've been injured in an accident, call my law office. I'll make sure you get the money you deserve. Not the money you want, not the money you need, not the money you think you should get, but the money you deserve. And that's that.
Call the law office of Sharon Sockamup at 555-555-5555. Attorney Sockamup is not actually licensed in any state within the union, but we're saying this really fast in the hope that you won't notice.
Hello and welcome to episode 5 of the Not Too Stuffy Law Show. I'm your host, attorney Justin St. James. For the next half hour, we hope to entertain, inform, and enlighten you, and if we don't, you should probably be watching The View. I'd like to welcome our studio audience. Gee, our audience is getting younger and cuter. How's it going? In this episode, we start off right here in the studio with 4 cases in tort law, all of them having to do with a train, and 2 of them involving a banana peel. You'll understand what I mean in a few minutes. We then go back to law school because the first time was just so much fun, and head over to Boston College Law School to speak with their Assistant Director of Admissions, Jose Roman. Mr. Roman will give us the inside scoop of what it takes to become a successful law school candidate, and I imagine most of his advice is relevant to all levels of academic institutions, from college to graduate school to medical or business school. What Mr. Roman says can apply to anyone seeking admission to higher learning. So stick around. There's a lot to learn, and you'll have a good time. Up first, 4 cases in tort law.
Tort. A tort is A, a clever remark that you say in response to someone else's stupid comment. B, the ratio of power between your car's engine and its wheels. Or C, a civil wrong for which a remedy may be obtained. And the answer is B. Well, okay, the answer is C. A civil wrong for which a remedy may be obtained.
I'm here with Katie Kohut, who's going to help me explain 4 cases in tort law, all of them having to do with a train in some way or fashion, and 2 of them involving a banana peel, which is why we have Katie eating the fruit at this moment. This first case is called Goddard versus the Boston and Maine Railroad. It comes to us from 1901. It's a very old case, more than 100 years old, but it's still a pretty interesting case. And the plaintiff in this case is named Goddard. Now, the plaintiff is the person who brings the lawsuit. He's the reason why we have a lawsuit in the first place. He's the one who was suing the other party, the defendant, in this case, the Boston and Maine Railroad, again in 1901. So let's use the wrestling figure as our plaintiff. He's going to be Goddard, and he has just, the train just arrived in Boston, in the Boston station, and everyone is getting off the train, and Mr. Goddard is also departing from the train, so let's put him over here, and he's walking on the platform, and he's walking across the platform, and we need your banana peel at this point. So leave that on the, yeah, there we go, like that. Right. And Goddard steps on the banana peel, and what do you suppose happens when he steps on the banana peel?
He's gonna fall down. He
falls down, so let us go, boom, just like that. So poor Mr. Goddard slips on a banana peel that someone had just carelessly left there on the platform, and he is injured. So he sues the Boston and Maine Railroad, saying, listen, the employees were negligent. They should have had notice. When we say notice, we mean awareness that there were obstructions on the platform, and the employees of the Boston and Maine Railroad should have made sure that the platform was clear of all the debris so that poor folks like Mr. Goddard wouldn't slip and fall and hurt himself on the platform. Well, here's the problem with the argument. The court said, this went to the Massachusetts Supreme Judicial Court, which is also known as the SJC, and they said, well, Mr. Goddard, here's the problem with your case. The banana looks like it's a fresh banana. It looks like someone had just eaten it and then thrown it on the platform, and then poor Mr. Goddard came along a few seconds later and slipped and fell on it. So that really doesn't give the employees of the train station enough time or enough notice, there's that word again, enough notice or awareness to understand that there are obstructions on the platform that should be cleared away so that folks like Mr. Goddard won't slip and fall on it. So unfortunately, he does not prevail. He doesn't win this case. So now we're going to jump 10 years into the future from 1901. We're going to go to 1911. Okay. And we have another case. This one is called Anjou. I hope I'm saying that correctly. Anjou versus the Boston Elevated Railway. Now in 1911, when they say elevated railway, I'm assuming they mean subway or trolley. This was probably a train that was up on a bridge of some kind. In fact, it took place at the Dudley Street Station. Now, I don't know if it's the same Dudley Street Station today that we all know and love, but it's certainly the same name, and again, it takes place in Boston. And again, it was 1911. So this time we're going to use our knockoff Barbie doll. There you go. She's going to be Mrs. Anjou, and she has just arrived on the Boston elevated train. She's just come off the train. And now, if you've been on the subway in Boston, you know that there are several different lines. You have the red line, blue, green, orange line, and you might want to get off the orange line and change onto the red line or whatever. Well, that's what Mrs. Anjou wants to do. She wants to get off the subway at the Dudley Street Station, and she wants to get on to another train, another direction. Right. So she asks an employee of the Boston Elevated Railway, she says, can you lead me to the other train? So she's following this other employee, I should say. There you go, we can use our wrestler.
We got him.
She's following him behind, and lo and behold, there's another banana peel on the platform, only this one is really different. This one is kind of old, and it's been there for a while, so they walk along. Mrs. Anjou steps on the banana peel, and what do you suppose happens?
She's gonna fall down.
There you go. Boom. So she falls down. Poor Mrs. Anjou slips and falls on the banana peel and sues the Boston Elevated Railway for injuries. She says the same thing that Mr. Goddard said 10 years earlier. She said, listen, there was notice, they should have known, the employees of the Boston Elevated Railway should have known that there was a banana peel on the platform, just like 10 years earlier when Mr. Goddard made the same argument. And so she sued the employees, saying they were negligent rather, in not making sure the platform was clear. Now, here's the difference. Everything else is the same, but pretty much here's the difference. This banana peel was described as dry, gritty, flattened down, and black in color. Dry, gritty, flattened down, and black in color. So what the court said was, well, if a banana peel is dry, gritty, flattened down, and black in color, it's been sitting there for a while. Unlike the first banana peel, see, you're still eating that one, that's a brand new banana peel. That's still yellow and it looks still vibrant. Whereas this banana peel, obviously it's been sitting there for a while. It could have been there for a few hours, could have been there for a day, a couple of days, a week. So what the court said was, listen, that certainly was enough time for the employees to have notice or awareness that they should have cleared away all the obstructions away from the platform. So Mrs. Anjou, I hope I'm saying her name correctly, Mrs. Anjou prevails. She actually wins her case in the slip and fall case against the Boston Elevated Railway. And thankfully, that's enough of the banana peel cases. We don't have any more.
All right.
We're now going to bring on some road here.
Okay.
This case comes to us from 1934. It's another tricky name. It's called Pokara versus the Wabash Railroad Crossing Company. Pokara versus the Wabash Railroad Crossing Company. Mr. Pokara was in his truck in 1934. Now, I don't have a truck. We have this Porsche, so we're going to make believe this Porsche is his truck.
All right.
Actually, if he'd been driving a Porsche, he probably wouldn't have had any trouble in the first place, but that's all right. So Mr. Pokara is driving along in his truck, and he comes across a railroad crossing. Actually, we'll do it like this. And he comes to the railroad tracks, and he can't tell whether or not there's a train coming. He looks left. He doesn't see a train. He listens for bells and whistles. He doesn't hear anything. He looks right, and unfortunately, there's a boxcar sitting right next to where the train tracks are, so he can't really see beyond where the boxcar is. So Mr. Pokara, he listens, he doesn't hear any bells and whistles, he slowly proceeds, go ahead, across the tracks, and he gets right about there, and what do you suppose happens?
I guess a train came.
A train came and hits him broadside or in the side, just like that, and as you can imagine, when a train hits you, let's make sure we can get this on the camera here, when a train hits you broadside like that, you're going to receive injuries, if not certain death. But fortunately, he lived, but he received injuries. So he sued the Wabash Railroad Crossing Company, saying that it was foreseeable, or they should anticipate, that there was no one there to warn drivers in their vehicles, whether they're driving a truck or a Porsche, or whatever it is they happen to be driving in 1934, no way of knowing whether it was safe to cross over the tracks. The defendant, the Wabash Railroad Crossing people, said, well, listen, 10 years earlier, there was a similar case where someone got out of his truck and he walked to the edge of the train tracks and he looked left and he looked right and he saw that there was no one there, so he safely got back into his truck and then drove safely across the tracks. But the court said, well, yeah, that's what we said 10 years ago, but it doesn't really hold true anymore, because by the time you get out of your truck, walk to the edge of the tracks, look left, look right, get back into the truck, start across the tracks.
The train could be coming.
Absolutely right. Absolutely right. So they said, listen, we're going to send this back to the lower court. This was actually the Supreme Court where this was heard, the highest court in the land, the U.S. Supreme Court. And so they sent it back to the lower court where it all began, and they basically retried the case. I couldn't find any research on as to far as what happened after that. I only have research as to what happened to the U.S. Supreme Court. In all likelihood, Mr. Pokara settled with the train company. He probably got some kind of monetary damages to make up for the injuries he received when the train hit his truck. All right, so we have 3 out of 4 cases so far. In 2 of the cases, the plaintiff won. In 1 case, the defendant won. Let's see what happens in this final case, this last final case.
All right.
This one is called, and every single lawyer knows this case, every single law student studies it in law school. It's called Palsgraf versus the Long Island Railroad Company. 1928, another old case, but still a pretty interesting case. This takes place inside the Long Island Railroad train station. And we have a train inside the Long Island Railroad station. And we have Mrs. Palsgraf. We're going to use our Barbie doll knockoff. She's standing there waiting for a train. Now, it's not necessarily this train, but she's waiting for another train to board so that she can go to wherever it is she's going, her destination. This train, which is already inside the railway station, is slowly pulling out. So it's slowly pulling out of the station. And at that very moment, as it's slowly pulling out of the station, 2 men come running up to the train, and they want to get on board the train. One man jumps on the train, he gets on, no problem, everything's fine. The second man, not so good. He's struggling, he's kind of hanging on to the train. 2 employees of the Long Island Railroad, they see him, they try to physically push him up into the train. They've physically got a hold of him, and they're pushing him up into the train, and they succeed. They finally get him into the train as the train's slowly pulling out of the station, and the train goes on to its destination. Now, you might think, well, so far so good.
Yeah.
Here's the problem. As the 2 employees, the 2 train personnel were pushing him into the train, a mysterious package that they did not know about falls out of the man's pocket. It falls out of his pocket and it lands on the platform of the train station, and it explodes. They were firecrackers. So in 1928, apparently this man was walking around with firecrackers in his pocket. I guess you could do that in New York in 1928. The explosion from the firecracker sets off a chain reaction. The platform starts to shake. The vibration goes all the way over to Mrs. Palsgraf, who's standing there minding her own business. And a scale, not the type of scale that you, like in your bathroom scale where you step on in the morning to see how much you weigh, not that kind of scale. One of those big heavy scales that you weigh objects on, falls on top of Mrs. Palsgraf. She in turn, boom, falls down and is injured. So poor Mrs. Palsgraf falls down. The scales are on top of her because of the vibrations caused by the firecrackers that fell out of this man's pocket when the 2 employees tried to help him up into the train. With me so far?
Yes.
Okay. She sues the Long Island Railroad Company saying, listen, the employee should have anticipated or should have foreseen or should have known that by helping this man up into the train, this package that they did not know about would fall out of his pocket, fall onto the platform, ignite, set off a vibration which would cause the scales to fall over on poor Mrs. Palsgraf, have her topple over with the scales on top of her and cause her injuries. Does it seem like a stretch to you?
A little, yeah.
It does, yeah.
It does.
And it is, and that's what the court said. This court said, well, Mrs. Palsgraf, we're really sorry you got injured. Actually, they didn't say that because courts are very sorry about anything. But they probably said, yeah, you're out of luck. It's really kind of too much of a stretch. It was not foreseeable for the employees of the Long Island Railroad, when they're helping this man on board the train, that a package that they did not know about would fall, ignite, cause a chain reaction for the scales to fall on top of you, and therefore you would be injured. So unfortunately, Mrs. Palsgraf is injured, but she doesn't get any kind of restitution for her injuries.
That makes sense.
So in the 4 cases, twice the plaintiff wins, twice the defendant wins, and I guess the moral of the story is, even if you're injured, you may not necessarily win your case. There are a lot of factors that get involved. You have to look at all the variables, all the elements that come into place. Especially today, it's really, really tough for a court to hear your case. Courts are very eager to make sure cases get thrown out. So you really have to be sure you've got a strong case, witnesses, all kinds of evidence that you can bring in would be helpful. And that is the story. Those are our 4 cases in tort. I appreciate your being here and helping me with the cases.
Oh, thank you for having me.
You've been great. Thank you very much. My thanks again to Katie Cohat for her excellent assistance in explaining those 4 cases in tort law. At this time, I'd like to check in with our studio audience. Guys, what do you think of the show so far? Guys, well, I'm sure they'll start to pay attention any minute now. It's just a matter of time. You may know that Boston College Law School is one of the highest-ranked law schools in the United States. Depending on which survey you read, BC Law is usually ranked within the top 25 and even the top 20 law schools in the country, which certainly explains why they rejected my application. Thank you. We spoke with their Assistant Director of Admissions, Jose Roman, to find out what it takes to get into an elite school.
And who sets the admission policy? I mean, who says we have to have a GPA of 3.7, we have to have LSATs of 166? Who sets that policy?
It's a number of individuals. It's collectively, as an institution, as a committee, a number of individuals are part of that conversation. The Dean of Admission, in this case, our Assistant Dean for Admissions and Financial Aid, is the head of our office. Myself and my associate as well can be part of that conversation, but also the Dean of the Law School, and also the Associate Dean for Administration and Finance. Now, it's good to know kind of the pyramid of authority at the law school. The Chief Executive is the Dean of the law school. Then you have a set of associate deans.
Some, I don't want to say, well, I'll say 4th tier law school, as they're ranked, like a Suffolk or a New England Law. And then they'll apply to Yale and Stanford.
Okay.
And they'll get rejected by Suffolk and New England Law, but they'll be accepted at Yale and Stanford. And you think to yourself, well, how the heck did that happen?
Well, I think a number of things, just understanding the psyche of an admissions officer. I think when someone has achieved and someone has put forth their best effort and has put together a very strong application, he or she should be rewarded. You know, these are professionals reading your application. This is a professional school. Therefore, regardless of what you believe are your prospects, you need to take this process very seriously and be a professional. Because especially when you're looking at schools that are quote unquote highly selective, have a ton of talent, knocking at their doors, you're one of many. And this process lends itself to a lot of nuance. An individual may be very gifted and very attractive at first glance, but an institution may make a decision and say, I don't know if this person will be happy here. I'm not sure if this person is looking, if what this person is seeking, we have to offer. So it becomes an issue of fit. So understanding that, at my previous institution, I worked at Yale University, undergraduate admissions, and you would always receive those phone calls from these individuals, these students who would say, well, I was admitted to Yale, but not to Harvard, and then I was admitted to Princeton. And you're wondering, how does that happen? Well, these are different institutions. Sure. And you always were curious when you hit the trifecta. The AHYP students, the Harvard, Yale, Princeton students. What did this person have that all of these schools really had?
Yeah, they want what they wanted.
So yes, you're looking for a fit. This process is it's multidimensional. There are a lot of layers to this, and again, this speaks to the idea that students are looked at. Each candidate has something different. And I believe that decisions are made on many different levels. But first and foremost, the academic qualifications, relative comfort with this person's academic skill set needs to come first.
Okay. Are there too many lawyers?
Are there too many lawyers? That's a good
You
question.
always hear that. There are too many lawyers.
Well, I think that the legal profession needs to understand that if the pipeline is cut short or cut off completely at one point, that becomes problematic because the law changes daily, and you need individuals that are coming up the educational pipeline, that are studying new issues, that are really young, vibrant, and really are looking to really leave an impression on the profession. I think that firms, I think that institutions that hire a lot of attorneys need to make sure that flow of talent continues to be produced, because these are the future leaders of the profession. I always tell students, potential candidates, think ahead of what you may want to do. Now, granted, you don't have a crystal ball. You may change your mind while you're in law school, but always always try to take an approach that will allow you to have options and not to just put you in one niche market or allow you to just think in one way. Because that quote-unquote flexibility that comes with the JD, yes, you can end up going into public policy in any number of directions, but it gives you flexibility within the profession. And I think most students go into law school thinking that they're going to practice law. Others don't, but most of the students that graduate from our school practice law.
That's a good point. When you get an applicant who is from a family of lawyers, say his father was a lawyer, his father before him was a lawyer, you're shaking your head no. I'm nodding. Oh yeah, you've seen it before. Okay.
Well, no, I've seen it, yes.
Okay. Do you think to yourself, well, does this guy really want to be a lawyer, or is he just doing it because it's expected of him?
No, because I really want to know
that. Can you tell in the
writing? I want to know why this person is motivated. If an individual, a potential law school candidate, has the opportunity during school or during the summer or at any point to have interactions with lawyers. You don't have to be a paralegal to go to law school. You don't have, but I think it's worthwhile. Just individuals, person, whether it's documented or not, it's worthwhile speaking with practitioners and understanding what the day-to-day is, understanding what a public interest lawyer does versus a corporate lawyer that's in transactional law. Understanding that is important. I think that it's worthwhile if that person has that luxury of being plugged into professionals in the field. But it doesn't have to necessarily be documented. Now, if I see it documented in a resume, or the person alludes to his or her family members being lawyers, well, I think it may be self-evident. I think it's self-evident in a resume. When someone has worked for a law firm, I think that person has asked questions, so I'm less likely to doubt that person's motivations. If a person family has a great tradition of legal professionals, well, I think someone should delve deeper, because any number of us would like to be like our parents, right, when we're kids. But I want to know what your individual motivation is. You need to step outside of that shadow and really say, well, I've observed my father or my mom. My father or my mom have really introduced me to other lawyers, and I'm set on going to law school for these reasons.
Okay. If you had a magic wand, and not necessarily here at Boston College Law School, because you've had experience at Yale undergrad as well, what could you do to improve the process? Or what, if you could fix something like that, you say, okay, we need to do X, and the process would be 100% better, work more efficiently, what would you do?
That's a good question. Process word.
See, originally the question was going to be, my original question was, what's wrong with the system? But I don't want to make it a negative, I want to make it a positive, so I'm saying, what could be done to improve this?
I don't see any. I think adding interviews would be a great thing.
Yeah.
It's just I respect too much the enormity of such an undertaking, especially when unlike, let's say, an undergraduate institution that has a much larger alumni base, has a much larger staff, can really draw upon a lot of different sources for interviews, and can rarely interview the entire pool. Requiring an interview is different from recommending one and making one available. At Yale undergrad, we recommended interviews, but we couldn't penalize someone who couldn't get an interview because all the slots were filled. So we couldn't penalize someone for that. I think if we, in an ideal world, if it were as easy as waving that wand, interviewing would be great. I enjoy interviewing. That's how I cut my teeth in admissions when I was a senior at my alma mater, Wesleyan University. When I was a senior, I was fortunate to have been offered a position in the admissions office as an interviewer. So I've done many interviews. I've never been interviewed on camera, but
there's a first for everything.
There is a first for everything. But it really does. It's amazing how it confirms what you already know in an application, but it also helps when you really are borderline on a candidate. It can really seal the deal, or one way or another. It can be. And when I tell candidates who want to come to our office and have an informational interview, because sometimes an individual may say, I have some questions for an admissions staff member. Mm-hmm. I say, that's great. I hope that before you go into this 5-10 minute conversation that you read the literature online and printed, that you've taken the time to get to know us. Mm-hmm. I don't think an efficient use of time is asking questions that are already answered in the literature. I think you do need to put your best foot forward, because although it's not a formal part of the process, you're still presenting yourself. Mm-hmm. This can still be considered.
Sure.
Whether good or not so good, an impression is left. And that goes with anyone in our office, not just an admissions officer. When you call an office, you're on. If you're less than respectful to our staff, whether administrative or not, support staff or not, that person can have an effect on the process. Because if you are not respectful, that person, it would be evident in the office, and someone can say, well, that so-and-so character was really not pleasant. Well, it's really, we want individuals that are going to be respectful, professionals, and it's important to our institution. Mm-hmm. And I think whenever you do present yourself, whether it's in a formal setting or an informal setting, I still think you need to be a professional. I need to be a respectful adult.
When is the best time to apply to law school? Is it right about now? Is it September, October, or is it?
That is more
of
that is more of an institutional question.
Okay.
But speaking from our process, which is a rolling admissions process, we opened up our application in late September. Okay. We're receiving applications now. If I were to just be more specific about when. Many individuals, enough folks take the December LSAT. I think by the holidays, or soon after the holidays, or soon after the December LSAT scores are posted, I would have my application submitted, if not completed.
Excellent. I appreciate your time.
Well, thank you very much.
Very informative. Thanks for being with us.
My pleasure.
Thanks.
If you want to learn more about Boston College Law School or the admissions process in general, you may contact the school at 617-552-4351. The school's website is www.bc.edu/schools/law. I'd like to thank our studio audience for being here. And it's about that time of the day. As we always do, we leave you with the beautiful music of the equally beautiful Sarah Melson. You may find Sarah's music on Amazon, iTunes, iLike, eMusic, Facebook, MySpace, and of course, sarahmelson.com. The name of the song is Happy Endings. Until next time, I hope all of your endings will be happy endings. I'll see you then.
I guess I just never realized how badly I needed to be surprised. You kissed me with your eyes, less than I do. Now I'm 1,000 miles away, waiting for the first light of day. And the way I'm feeling is oh so new. And I believe in happy endings, and I only see the good in you. And I believe the world is worth mending. I think that you do too. I know that you're an optimist. You're pretty impossible to resist. And I know